It's pros and cons of a probate court confirmation sale. This can be a little tricky one, so make sure to watch this next. Welcome back to the channel featuring the leading probate real estate team in the greater Sacramento region. I'm Brendan Mohr, Realtor and Certified Probate and Trust Specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed California professional fiduciary. I'm also a registered and bonded California legal document assistant, specializing in uncontested probate work, as well as I'm a licensed California real estate broker.
Now, please like this video, subscribe right now. Want your probate done for no fee? Well, every day we help people save thousands of dollars and eliminate headaches with our cost savings probate administration service and real estate listing combo. So if it's in California and real estate needs to be sold, reach out to us. Our info is in the About section on this channel. We love your calls, texts, emails, and comments. Now let's get into it. Okay, so it's pros and cons of a probate court confirmation sale. Now, this is usually something that is probate and limited authority, where after an accepted offer, it sometimes takes a couple of months, maybe longer, to get to the court confirmation hearing for the court to confirm the sale. Sometimes it happens because there was an heir who objected to the sale. But here, we'll go through pros and cons. And Bill, you're the good guy on this one. You're gonna be pros, I'm gonna be cons, or
right.
You don't want one. Okay.
I'll be the good cop.
Yes.
Okay.
And for the record, I don't like court confirmation hearings. It's a long process.
Yeah.
Not necessarily the hearing itself. I feel like I could get things done for the estate a lot faster.
Absolutely.
Yeah.
Absolutely. Okay. I've got my list of pros here, so I'm going to just go down my list one by one. The first pro is that you've got court oversight. And what I mean by that is you've got the court basically overseeing and confirming the entire sales process. The court's going to make sure that the sales price is correct. The buyer is going to be ordered to do what they need to do to complete escrow. And it's actually a more beneficial situation if you've got heirs that are not real cooperative with each other. Maybe there's trust issues there. So that's one of the pros.
Oh yeah?
Mm-hmm.
Well, I'm gonna counter that with, well, it costs more. There's more upfront costs. It's not a tremendous amount of cost, but there are more upfront costs, such as possibly attorney's fees, or there's definitely filing fees, publication fees, because you have to publish the hearing to try to attract overbidders.
Yeah. Could be more attorney's fees too.
Yep, absolutely.
But I'm going to counter that. The overbidding process and the court confirmation, you've got transparency. All of the participants get to witness the bidding. They get to see exactly what's going on. They're all given paperwork ahead of time before the hearings so that they know all the terms of the sale, everything that's going to go on. So the transparency is very good. It's very good.
Well, if you want your money quickly, this is a bad way to do it because it extends the timeline. You have to wait months more for the court confirmation hearing to take place. There's a far more likelihood of it falling out of escrow and having to start the process over again. And a lot of people think that once the house sells, the heirs get their money, but no, that's not when you get your money. All that money goes into an estate bank account, and it takes finishing up the whole probate, filing that final petition, and getting to that final court hearing to distribute the funds.
That's true. However, with the court confirmation hearing, you're actually probably more likely to get a cash transaction. Sales to overbidders involve primarily cash transactions. They have to come in usually with a 10% cashier's check for the amount of their overbid. And generally, once the court confirms it, it's usually a cash transaction. Cash transactions are more favorable to pretty much any real estate sale, but especially to probate sales, cash transactions are good.
I would agree with that. However,
okay.
You are limiting the buyer pool. Because the process takes so long, and in real estate, when somebody is getting a loan, there's a rate lock period, and the regulations in lending are very strict for the time from start of the loan process to the finishing of it, that you often will lose that buyer who has a loan, so you're only dealing with cash buyers. That limits the buyer pool, thus maybe causing it to have a lower sales price.
That's true, but another pro here is with a court confirmation sale, you're going to get additional market exposure that you wouldn't otherwise have gotten, because publication of the sale is required in a newspaper of general circulation in the area, such that there are buyers out there who specifically look for these notices about probate sales. So you actually, in a way, you are opening up a little wider the marketing that is done for the property.
Well, I do like that, but I must say, you have a potential for a lower sales price, and it's usually because if it's a sale that from the start was advertised as the administrator of the estate has limited authority, the buyer already knows it's going to be this long process and there's fear of overbidders and all of that. So you get, again, a smaller buyer pool from that way. So you may not have as high of an offer price.
Yeah, it may not even out. I see what you're saying.
Even though there are some parts of that process, limited authority, where you have to have a minimum amount.
I can't disagree with you. I can't disagree with you. But I'll tell you another pro about court confirmation is contingencies. The nice thing about a court confirmation is that, number one, technically all contingencies are supposed to be released by the time the court hearing rolls around to confirm the sale. But even if they're not, for some reason, as soon as the judge orders that the sale be completed, confirms the sale, that's it. Contingencies are gone. And regardless of what the buyer may think, all his contingencies are gone, and he has to proceed to make the purchase. He can't back out. At least if he backs out, he's going against a court order and will definitely lose his deposit. And he may even be ordered by the court to pay some punitive damages that the estate may incur because of him backing out after the court order.
I do like that, but it also makes it more probable for the buyer to never even reach the court confirmation hearing and backing out due to the long delay.
That's true. That's true. However, another pro is that the court confirmation hearing ensures that the sales price is at least 90% of the probate referee's value of the estate as of date of death, or if it's been more than a year since the property owner passed away, then the probate referee will do another appraisal to get a current market value, and the price has to be 90% within that value. So in a way, it helps ensure that you're not going to get, the property won't be sold for well below market value.
In that situation with the second probate referee, that's a whole nother cost.
It is. It's more cost.
That's a bonus con on my side. This is a really serious con right here. A lot of people think that a court confirmation sale is good because it's going to generate overbidders, and whatever price you got in contract, there's going to be, people are going to start bidding it up like it's an auction. And the minimum overbid is the amount that is on the contract plus 5% plus $500. That's a loose way to put that formula, which is a lot higher. But the reality is overbidders are rare. It's not that common that they actually show up. So you're just elongating the process to confirm the sale of the buyer that's already in contract.
The last pro I've got, which is one I've already mentioned, but once the judge signs the order confirming the sale, that's a court order, and the buyer can't back out. He's got to go through with the sale. He's under court order to do so.
Now, the hard part about that, though, is after the sale, my last con here, after the sale is confirmed, if the buyer doesn't abide by the contract, well, it takes a court hearing to cancel the sale. So it could take weeks or months of waiting. And I actually had somebody, a realtor, a great realtor from Southern California, and thank you so much for reaching out to me about this. She went through the whole ordeal that there was an overbidder. They had a great buyer in contract for the cash sale. An overbidder comes along, bids on it, doesn't abide by the contract, and keeps playing those games. So they're in this boat of, do we have to go back to court and pay another fee and pay the attorney more in this case, or do we stick with this one? It actually took, I believe she told me it took months to actually close that one when it was only supposed to take a matter of weeks. Well, that was fun, Bill.
Yeah,
any other
I
pros or
enjoyed it.
cons you like to? Yeah.
I think I've got all mine down.
I'll tell you, it is far preferred if you're in the full authority route. You don't have to go through a court confirmation sale, because I just find that is most likely going to be the better result overall for your estate.
Yeah.
And if you're having difficulty doing that, it may be just simply because of the strategy of who's probating your estate. So reach out to us if you're having an issue with that, and maybe you want to have somebody else take it over. Now, this next video is an important one. We get to the cost of probate and how much you can end up paying, how much you can actually save with certain strategies. It's called, How Much Does Probate Cost in Sacramento County? That's the county that we often operate in. It works for a lot of other counties as well, and that video is going to come up next. It's going to appear right above Bill's face.